First item on the agenda for open session after the executive session is a motion to seal the minutes of the executive session held on March 3rd, 2026. Is there such a motion? So moved. Motion by Commissioner Brown. Is there a second?
Second.
Second by Commissioner Susie. Roll call vote. Commissioner Susie.
Aye.
Commissioner Peterson.
Aye.
Commissioner Browner. Aye. Commissioner Callahan. Aye. Commissioner Centerady.
Aye.
Commissioner Radu.
Aye.
Commissioner Ritchie.
Aye.
And the chair votes aye. Next item on the agenda is I need to read out the events that occurred during executive session. First item on the executive session agenda was a motion to approve the minutes of the executive session held on June 20th, 26 pursuant to RI General Law Section 42-46-5, A2 and A4. 7-0.
Yes.
Yes, and I have a vote of 8-0 on that motion. And then in the matter of did you abstain on that motion? I'm sorry, sir. Did you abstain on the motion to approve the minutes?
Yes,
You
yes,
did. So it was 7-0 with one abstention. The next item was In re James Durkin, complaint number 2025-4 pursuant to RI General Law Section 42-46-5, 8, 2, and 4. In that matter, the commission voted 8-0 that there does not exist probable cause to believe that the respondent James Durkin, an elected member of the Narragansett Town Council, violated Rhode Island General Law Section 36-14-5A by his participation in Narragansett Town Council's discussions and votes relating to amendments to the town's zoning ordinance on various dates in 2025, including February 18th, April 21, May 19th, June 2nd, and June 16th, all in 2025. And then the commission then reviewed a proposed settlement resolution. I'm sorry, a proposed informal resolution of settlement in the matter of In re Jeffrey McCormick, complaint number 2025-6. In that matter, this matter, the commission voted 6-1 with one recusal to approve a proposed informal resolution and settlement. The executive director will advise when copies of the settlement document will be available. Yes, and then the commission voted 8-0 to return to open session. That concludes the report out, the actions taken in executive session. I believe that brings to the floor what amounts to our last matter on the agenda today. Pre-trial motion hearing in the matter of In re James E. Thorson, complaint number 2023-7 on respondent's motion to exclude certain hearsay, irrelevant, and unduly prejudicial documents. Would counsel identify themselves, please?
Sure. Attorney Kevin Costello for respondent James Thorson. Attorney Fred Kelly for respondent James Thorson. Jason Brandon for the people of the state of Rhode Island.
Before we start the actual discussion of motions out of the motion, I want to say a couple of things. First of all, I want to thank the parties for providing this motion and the opportunity to have this hearing. Inconsistently with the rules as they apply, typically you would only be required to do this 5 days before our scheduled hearing. It's extremely helpful to us that you are willing and able to do this now. I will note that your motion to preclude or exclude the evidence, I believe we received on February 18th and was quickly provided to the commissioners. Provided separately from the March 3rd meeting package. We also received the objection and we received your reply, and they were all provided very quickly to the commissioners, so they've all had the opportunity to review those matters. I also want to indicate for the record that there has not been a single discussion among the members of this commission on any substantive issue relating to this motion. We are all here independently, having reviewed the materials and considered what you presented. I want to confirm, I guess, with the respondents' council that you had received the two certification of public records in time to have had those at the time when you filed your motion. You don't understand.
Yeah, neither one of us recalls receiving the certifications. Prior to us filing our motion on February 18th pursuant to your order. I think if you look at one of them, I think it's dated after, anyway, after we filed. I don't think it makes a ton of difference on our positions, but, the direct answer to your question is, you know, I never saw them.
Well, but they are dated December 4, 2025, and January 13, 2025, 2026 rather. And again, I have no reason to doubt that. I just wanted to confirm from you all that you had seen them before we got here.
I saw them when we read them. I'm sorry, you want to stand out, but yeah, I saw them, and I think Mr. Kelly did as well. When we received the prosecution's objection to exclude.
With those certifications in hand, is there really an issue of authentication here?
Yeah, yes, I think
Or
there is.
disability?
Yeah, I think rule 901 and 902 as it relates to the authentication statute and the rules of evidence requires more than is contained in the certifications. My reading of those two documents indicates that they're certifying that their records kept and maintained in the ordinary course of business by, they don't use those words, they don't use ordinary course of business as a keeper records of business, but kept in the normal course of the operation. For example, with Mr. Stoley, the Department of Administration for the state of Rhode Island. And I think that rule 901, rules 901, 902 require more than that. Yeah, that's my position. Now, yeah, so that's, and as you know, so authentication is a condition precedent to admissibility anyway. You just said that, I understand.
Which is kind of why I'm asking, because you have two people certifying these documents as true and accurate copies of the documents. And except for the website. And so I'm just, to me, what we have before us today is not really an authentication issue. They are what they purport to be. It's an admissibility question.
Yeah, I would agree with you that our principal arguments are admissibility and relevance. And also there's the 403 unduly prejudice versus probative value. I think that as it relates to, I mean, I didn't even look at rule 901 or 902 in connection with this until I read the objection. And there was, this claim of authentication, which I didn't think really addressed what we were directing our motion to exclude on. So we responded to that in our reply memorandum and other things.
As I say, we have that.
Yeah.
I'm just trying to make sure I understand. Because, yeah, to me, the nature of the documents themselves are certified as being true copies. And unless someone's going to come in and say, no, they're not, then I don't understand how they can't be treated as authentic. Disregarding admissibility. They are what they purport to be, aren't they?
But I don't think that we dispute that.
Okay, that's what I'm trying to get at.
Yeah, and if I didn't say that a minute ago, I meant to.
Just centering.
Can I just get a clarification of the dialogue between the chair and council? Number 12 has been, that particular exhibit has been redacted. Portions of it have been blacked out. Now, regarding authenticity, I mean, I have a concern that the original document that might have been received, which may well have qualified for admission. Once it was redacted and presented, is it an accurate copy? When did the redaction occur?
I think I'll let Prosecutor Graham explain that.
Yeah, I'm happy to. So that document was sent to us from the Department of Administration redacted that way.
Right,
And it was redacted, so we didn't redact it.
right, I know that.
And frankly, the sections, I included it in what we gave to the respondent way back when, we provided all the evidence that we had against this client and included it in full as an exhibit, including the redacted parts of that thread, just out of fullness, just so that you would see what we have. But in truth, there's really only one email in that exhibit that I plan to discuss at the invitation, assuming it's evidence. But no, we didn't do the redacted. The true copy of a redacted document was provided to the prosecution by the Department of Administration.
I understand, and it was, the affirmation was made, and I accept that the prosecution did not redact it. But once it's redacted, I would assume it was redacted subsequent to the original being filed with the department. And how, is it an authentic document then, that within the certification, if it was subsequently redacted? Prior to it,
So let me try. I think, because we're gonna have to go through these documents one by one. That probably is an issue that could be raised when we discuss exhibit 12.
right, and I raised it now because
I appreciate that.
you were getting, I thought you were more or less saying all of the documents have been authenticated, which I don't tend to agree with.
And I fully appreciate your point. But I just think we're gonna be at exhibit 13, 12, whichever it is at some point, and we might as well talk about that
Okay.
then, specific to it. I want to make clear on the record that if anybody feels they need a break at some point along here, put your hand up in the air. To the commissioners, you know, I'm open to your comments and involvement pretty much openly. And so once we get going on the arguments, I expect, understand that you may specifically have questions. You don't need to wait for me. And I think with that, I'm gonna turn to our counsel to give a short preliminary statement about where we are and to explain to the commissioners what the procedure will be.
Okay, good morning. Commissioners today conducted a hearing on the respondent's motion to exclude certain exhibits proposed by the prosecution on the grounds that the documents constitute hearsay, are irrelevant, and or are unduly prejudicial. They may also claim that some of the documents have not been properly authenticated, as discussed earlier. As this motion has been made and is being heard prior to the evidentiary hearing scheduled for March 17, this motion is considered to be a motion in limine. A motion in limine is a procedural tool used by parties to prevent prejudicial evidence from reaching the fact finder. Commission, you all are the fact finders. The phrase in limine means at the threshold. You will hear arguments from both parties as the prosecution has filed an objection. The respondent is seeking an order excluding 23 separate exhibits, which have been proposed by the prosecution from being admitted into evidence. You will need to rule separately as to each proposed exhibit. And I have actually numbered them when we do the motions. Now, you may defer ruling as to a specific proposed exhibit if you determine that you do not have before you all of the relevant information that you might need to make a decision. Okay, so with respect to some of the exhibits, if after hearing the arguments of the parties, you don't think you have enough information or you need more context, you can defer ruling on the motion as to that specific exhibit to the evidentiary hearing in 2 weeks. You can ask, as you do in all matters, you are free to ask questions of the attorneys while they're making their presentations.
All right, yes.
The respondent's motion, so the respondent goes first.
Oh, yes. And I take it that, Mr. Bristow, you're gonna make the presentation.
I am, yes, thank you.
All right, then the first item before the commission is a motion to exclude prosecution's proposed exhibit number 3, a Department of Administration webpage comprised of statements regarding the Department of Administration that were not authored by Mr. Thorson.
Yeah, that's correct. I'll do that.
I'm gonna read the preliminary on those motions each time so we know and the public knows what we are addressing.
Is it the intention of the chair that we vote on each one separately at this time?
As I'll let council answer that question, but we're going to have to address each one to vote one of, I believe, 3 things. Correct me if I'm wrong. Grant the motion, deny the motion, defer the motion.
All done here in open session.
One by
Each one.
one by one.
All right. And you can rule on each one as we go, or you can wait until the parties argue as to all of them and then revisit them. It's really up to you.
Can I ask you a question for this? Of council, assuming without admitting that there's a negative vote on, to admit one of the, matters that the state is proposing. That could, the state is free, is it not? To offer it again during the hearing?
What's that?
I believe the state must offer them during the hearing to create the appropriate record in case they choose to appeal. So what would happen at the hearing is they would still be proposed. They technically, as Mr. Bristow knows, are still subject to consideration unless we've made an absolutely clear ruling that they're not coming in. We could reconsider those issues at that time. And so the answer to your question really is when we get to the trial, yes, I think those exhibits have to be marked. Yes, we may revisit the question of whether they're marked full. And this hearing today will probably inform those decisions then, but we need to recognize that both sides are going to need to put before us documents that we may not accept as full exhibits, but that they have to put before us to create the appropriate record. Fair enough, Mr. Bristow?
Yes.
They have to restate the objection at the hearing to preserve all of their appellate rights of both.
So if we make a decision today that either party disagrees that they can't appeal from this hearing,
I do not
No.
believe so.
They cannot appeal from this. There's no interlocutor or appeal. Is that what you're asking?
Yeah.
Yeah, no.
okay,
I think of 4235 15 appeal, which is what this would be, has to be from a final order.
okay.
That's my
That's-
understanding.
I'll give it a minute to get it.
And that's why they have to restate
Resent,
their
yeah.
objection at the hearing.
Got it.
All right, Mr. Bristow, first item,
Yeah,
please.
well, with your permission, Mr. Chair, can I just make a very general statement, 90 seconds, 2 minutes?
It's your podium, as I always say.
Okay.
I don't mean to control your argument. I just know we have to deal with them one by one.
Yeah, understood. Look, a lot of these objections, I think you're aware, there were 33 proposed exhibits which were provided to the respondent in this case. We had no objection to 10 of them, but there are the other 23. And what I want to point out, and I think you may know this, is that 17 of them were either emails or text messages. Actually, 14 were emails, and 3 of them involved text messages. And we'll go through those exhibits one at a time. And you're going to see, though, as we do that many of those exhibits you know, my client's not a party, he's not an author of them, I mean, there are some, he's copied. Sometimes he's one of a whole string of people, 9 or 10 people who are copied, but he's not there. He's not an author, it's not authored by him, and I think there has to be a demonstration before they're ordered in that he at the very least saw them, and that's gonna be part of my argument, you're gonna hear that repeatedly as we go along. And a part of this, and a lot of this, I think, as it relates to our assessment of these exhibits and whether we were gonna object to them, is that we were advised by the prosecutor, by your executive director, that the only witness that he intended to call at the hearing was the respondent. That there were not gonna be any other witnesses, and that he was gonna rely, I don't know what he's gonna rely on, he'll tell you that. But from my review, hearing that, knowing that, is that these documents, needed to be, I thought that it would require us to object to documentary evidence that was, either attended to, Mr. Thorson's testimony, or maybe in place of other people who maybe should be here testifying before, at least from our perspective, okay? So that is important, you know, that our principal objections are hearsay, that is, as it relates to some of the, a lot of the documents, prepared documents, as well as the emails. These are out of court statements, offered for the truth of the matter contained therein, and relevance. And when I go to the first few documents, I think that's what I'm gonna talk about. I mean, from my client's perspective, we want this commission to focus on the lunch. Okay, March 10th, 2023, and the allegation that there was a failure to pay for a lunch that was provided by a state vendor at the time, Scout. Okay, and that's where we're gonna, you know, direct a lot of, I'm gonna direct a lot of my my conversation with you, and excuse me, and arguments. I'm just getting dry, I apologize. This may be silly, but a silly analogy, but I mean, from my perspective, as it relates to the lunch, we're talking about something that happened, and my baseball analogy is, you know, what happened in the ninth inning in a game, and we're hearing about the history of baseball here, because so many of these documents, at least the ones I'm going to talk about, you know, are things that just aren't relevant. And the extent to which they are relevant, they're minimally relevant. Yes, there is a Department of Administration, that's Exhibit 1. They have a webpage. You know, my client didn't author it. I don't think it's meant to be comprehensive as it relates to Department of Administration. Rolling into Exhibit 1, by the way. But you know, there's like the very top is about the bridge alert or something like that. This isn't, I apologize, it's Exhibit 3. It's the first one that we object to. And there's I guess the guy who's a director, it's not a picture of my client, it's undated. It's not admissible. You know, I don't know what theory it's admissible. I mean, it's general information on, I guess, one page of the Department of Administration about us. You all have it in front of you. And I think the statements made here, I guess are here to say there's no statutory sites. And secondly, they're certainly not authored by the client. And secondly, I just think if it's relevant, it is just pretty minimally relevant. Exhibit 4, is I can go through these things.
Let me just stop for a second. I want to ask the commissioners, would you prefer to have Prosecutor Garamet respond to the first one, the webpage, or would you prefer to hear the whole argument and then let Prosecutor Garamet present his whole argument?
And when would, in your suggestion or for guidance, when would it be appropriate for the commissioners to ask questions? Because you don't, I just want to know guidance.
My perspective is that you should be able to ask questions anytime you want, because we're going to have different people making presentations. So if you have questions of respondents counsel, I think you should ask them as we're hearing the argument. In the end, we're going to have some kind of a vote, and maybe that will have been our discussion on the document. So when we're on number 3, I guess this was, if you have questions to put to the respondent on number 3, they should be put during the course of his argument. But my real question right now is, do we let him proceed to Exhibit 4, or do we ask Mr. Graham to get up and argue Exhibit 3?
In a true trial setting, he should proceed going forward and Mr. Graham should respond afterwards.
And is that a consensus?
On all of them or part of them, I don't understand.
Well, how else are you gonna conduct a trial, Judge?
No.
This is a
I
trial.
defer to
Let's-
Commissioner Kelly.
Yeah, it's, I would say as a layperson, that there's an important. Certainly for me, I don't necessarily mean this is the direction we need to go in, because this could take, X amount of minutes or short amount of time. But I do off of the defendant's information, I have a question for the prosecutor, but I would yield to the committee expertise, commission expertise and how this works.
Let me ask you, because are you suggesting you would prefer that we do them one by one? Or you-
That would be my initial preference without any experience, and if you would allow for it, once we got 2 or 3 in and we all went, oh, I got how this works. Let's go to if people are down with that.
I'm gonna present a counter opinion to that. I would like to hear Mr. Bristow go through each of his issues on each exhibit. Be able to take notes on that, as long as you don't bounce around. You know what I mean? As long as you go in a nice sequential order. And then I would be able to appropriately listen to what the prosecution's comments are on each one. That's how I would like to do it, but
Otherwise,
again,
we
I
do it
defer as
forever.
well.
So I would comment that for the lawyers here, they're used to going to a courtroom and they're used to have things proceed in court. For the lay people, they're not. The non-lawyers, I should express it more nicely. I'm inclined here to let Mr. Bristow go. But I'm also want to make sure each of you knows that when he's on a particular document, you can interrupt him, because what I don't want to do is go through whatever this is, 23 documents, and then say, well, Mr. Bristow, what about number 4? So as we're going through, for example, Commissioner Centerine, when we're on that particular document, that's when I believe you would be jumping in on it, either with respondents counsel or the prosecution.
Can I ask you another question
course.
for guidance? Is my understanding correct? That assuming something comes in on an exhibit, that does not address the weight, the truthfulness. I mean, we're free to say, okay, exhibit 14Z came in. And basically it comes in, but we decide it's total BS as
Right.
far as our decision. Am I correct in that?
Correct. The first question, is it admissible? And if it is admissible, then the next question is, what weight are you going to give to it?
And that's when we reach, having heard the evidence and we deliberate, that's where we will decide what the compelling and not compelling evidence is.
That's from March 17th, the determination as to what weight you're gonna give the docket.
Everybody comfortable? Commissioner Callahan, you okay?
Yeah, I mean, I guess I would say. So addressing Mr. Bristow, good morning. Perhaps you could share with me as a non-attorney, what do you think the purpose of Exhibit 3 is?
Well, given the fact that it's. Are you gonna prove there is a Department of Administration that has the 1-page website? There's no date on it, there's no I guess my direct answer to your question is I don't think it serves a purpose in this case. I think especially given, you're gonna hear from the department,
Sure.
the director at the time, who's the respondent, I'm sorry, go ahead.
No, and trust me, I'm here to listen, learn, and do my role. I would argue, though, as I went through the exhibits, this was, to me, the initial sort of very broad look at what the responsibility of the respondent and his organization was. Was my take. So I understand, what you are sharing with us, but but as a layperson, I didn't read it as hearsay. I read it as the beginning of a contextual theory as to why there may be, different levels of responsibility for the respondent as we move down through this process. So that's just where I'm coming from. I can handle the note writing and I can pause there, but that was my initial sort of take.
So let me make one comment which may give you some basis for thought, which is Mr. Bristow doesn't have any obligation to tell us why they want to present it. So a question about why it's being presented, what the relevance is, would go to Mr. Grammett, right, technically. He has the burden really of showing that his evidence is relevant. So again, I think they're good questions. I don't want to interrupt your question at all. I just want you to understand that distinction. Any other?
This might help along the way for non-attorney practitioners who are commissioners. You have it in your motion, but if you just summarize as you go through the objections for each document, because I know you wove back and forth between hearsay and relevancy for the first one. I think it would help my fellow commissioners if you, at the end, you just said, and the objections for this one are hearsay and relevancy. I think hearsay is across the board, and then not all of them had a relevancy objection. So just so when we're taking our own notes, we can ask questions directly to Grammett, and then we can hit each specific objection eventually.
Yeah, understood. Thank you. Could I give one further response?
I just want to say one thing for the record, which was, it was really a 3-to-1 of the non-lawyers to have them be done. 2-to-1, 3-to-1 with Commissioner Susie, to have the motions be gone through one by one. I don't, as you know, don't like making command decisions. So I do want to ask at this point of the lawyers and the judges, are you okay if we do it one by one?
I don't care.
I know, Commissioner Ritchie, I think you've expressed your view on it. Commissioner Center,
I would prefer one by one. I understand Commissioner Rapidu has an opposite view.
Are you saying, Judge, you want the respondent, to after each presentation, then the prosecution responds to that, and then we vote on that? Is that what you're suggesting?
I'm not saying vote, but I'd like it addressed personally.
Commissioner, I'll answer the last piece. We will not vote until we've heard the entire argument. We will not vote on any document until we've heard it all.
Okay, but again, so you're gonna ask, if we're gonna go one by one, and then we ask questions at the conclusion of each one from both sides, we just do nothing? We don't vote at that
We
point?
vote at the end based
So we
on,
have to recall everything that was said, and then vote,
yes,
not at each point?
I believe that's how we will proceed.
Okay, I am.
Otherwise, Commissioner Ritchie, what we would be doing is 23 points from Mr. Bristow. We'd be hearing 23 points from Mr. Grammett, and now we'd be deciding the same thing, which is how are we going to address
And
23 documents?
That's what I'm saying, that the economy here.
I won't disagree with you about economy. I want to stay for the record, though, that in my time on the commission and every single commissioner who's here, we've never had a proceeding like this.
Right, it's true.
And so I want to say that we are working our way through the process as we sit here, because of course I could not dictate the process that we would follow, nor frankly could our counsel. But I will ask our counsel his perspective on this.
No, I think it's, the best way to go would be as to each specific proposed exhibit to which there's a motion to exclude, that Mr. Bristow goes first. Any of the commissioners who have any questions of Mr. Bristow at that time, ask the questions, he can respond. When he's done, then Mr. Grammett gets up, he addresses that specific exhibit. Anyone has any questions, they can ask, okay? And then we move on to the next exhibit.
Which I'm gonna say again, means you have no rebuttal response. It's just your argument and his argument. Based on the opinion of counsel, I think we will go one by one. I don't know whether I fully agree with our counsel that we stop and ask questions of either counsel until we've heard the entire piece on each one.
and then direct our questions as we see
Yeah.
fit.
That's fine, and so Mr. Bristow goes, then Mr.
Grammar
Grammar,
goes,
Yes.
then
that's fine.
Okay.
And then we have to recall
I
everything
will,
that was said.
let's
and then vote.
consider at the end of the first one, how we wanna
See how it
proceed.
goes,
Okay.
Fine.
Okay, Mr. Bristow, you've addressed somewhat, there's one other thing I wanna say. There's a point at which, because there's so many things in here that it's the same. That you don't need to go through, and I don't mean this in a negative way, but you don't need to go through the same arguments on each one. You can say, this is why, you've heard a little bit about this before. And move from there.
Yeah, understood. Thank you.
Okay.
And I did want to make one further response to Commissioner Callahan, but you want me to wait now? Bill,
right.
Mr. Graham has spoken to you and then I
No,
can
you,
do that?
let's do that now, because you've asked the question.
Okay, yeah, I just, it's one of the things in the law that can be difficult to understand. I mean, you said, well, it gives you like a general broad overview of the Department of Administration, doesn't mean that it's admissible. You know, the rules of evidence, and I tell this to my clients, I tell it to witnesses, I tell it to, you know, I use the context of a trial, but this is a trial topic, really. And it's, you know, it's the rules. And it's not like having a conversation with someone where things that are relevant, you might say, yeah, that's great, I'll consider that, or you're doing all that. It's, there's the rules of evidence and all the cases that flows from them. Prescribe, you know, what it is that a finders of fact are allowed to consider. And that's what a lot of these objections are. Okay, thank you.
Might I just say? The authority of the Director of Administration and the responsibilities of the Department of Administration are set forth directly in the general laws. This seems, any conflict between the documents, the general laws would control. And sometimes to try to have people understand rather than reading the general laws, they put something up as an informative nature. So I'd like to say on a website, so people can understand it versus trying to figure out what the general law is.
I'll sit down.
You're rest on number 3.
Yeah, I think that's the procedure you want. Yeah.
Yeah,
nothing
well,
else to say.
you're done, you tell us when you're done, and I'll turn it over to the prosecution.
Thank you. Good afternoon.
Still morning. Thank you.
Yes.
Only seems like afternoon.
Yeah.
I'm going to address Exhibit 3. The Mr. Thorson's counsel seemed to have given a bit of an opening statement, and with your permission, I'd like to do the same.
I think that's appropriate.
I won't go on for too long here, but so all of these proposed exhibits that are being objected to, you know, there seem to be 3 issues. One is the authentication, then secondly, claims of admissibility under hearsay, claims of admissibility under relevancy. For the reasons that are outlined in my objection, all of those should be rejected. I did receive yesterday afternoon the reply to our objection. And given the timing of this case, I suppose I found a case that I wish I had included in my initial objection, but with your permission and based on the reply that came yesterday, I'd like to share the case with you. I have copies for every commissioner. I have copies for opposing counsel. I think it will be an important case for you to consider as you're going through these issues. With your permission.
What case is it, please?
The case is Di Pasquale.
They all have a copy of Di Pasquale. Every commissioner has a copy of Di Pasquale.
Very good.
And they've had an opportunity to review Di Pasquale, I might say.
Fantastic. Would opposing counsel like a copy of it? So Di Pasquale, I'll use my opening statement just to summarize it in 1 minute, is a case that is pretty much directly on point for all of the issues that you're going to be deciding today. It was an administrative proceeding before the DMV. The issue was the authenticity and the admissibility of a photocopy of something that was sent from another public agency. What our Supreme Court said was, first, this is an administrative proceeding where the strict rules of evidence do not apply. Instead, we look to the administrative rules of evidence that are set forth in the APA, and in our case, our commission regulations. That's number one. They went to admissibility before authenticity. We could go either way. But what they found was, first of all, and this is something that is just repeated over and over again in the decision, and that is that hearsay evidence is permitted in administrative proceedings. Period. Hearsay is allowed. So to the extent that these objections are based on the fact that it's hearsay, so we can't let it in. The Supreme Court, in a case very similar to what you're looking at, has said clearly, hearsay evidence is admissible in administrative proceedings. Quote, both the United States Supreme Court and this court have stated directly that hearsay evidence is admissible in administrative proceedings. So that's as to that admissibility issue. Is for authenticity. The court relied on the same thing that I cited, the same section of Rule 901A, 901, that I cited in my objection to say that public records are admissible. They're authenticated. In this case, every one of these records is a public record. And while I think you're going to hear arguments that email are not public records, but of course, record. Any record that a public agency maintains as part of this regular business is a public record. And the email that will be at issue, and I'm not going to harp on it, but Exhibit 21 and 31, our Attorney General has called it a public record. Well, I'll get to that when we get to it. So these are all public records, whether they're emails, even Exhibit 3, which I will now pivot to now discuss Exhibit 3, which is a photo of a web page. That is a document that was provided to the Ethics Commission by the Department of Administration. So the Department of Administration maintained a copy of that exhibit and sent it to us. It was a public record when it existed, when it got created at the Department of Administration. It again became a public record the day we maintained it here at the Ethics Commission. So it is a public record. And to be clear about what it is, it's just a printout of the DOA's webpage. By the way, if you go on the DOA's webpage right now and hit About Us, that same page exists. By the way, for that very reason, at the adjudication, that's all I need to get it admitted, is to say, commissioners, may I please show you that this is still current, and you may take judicial notice of the fact that this is what the webpage says. Now, as to its relevance, that's for you to decide at that time. Its weight, its importance to the case. As to every single one of these exhibits, they should come in, and at the adjudication, you'll decide, well, it wasn't that important of an exhibit, or, oh, I give this one a lot of credibility, a lot of weight. This one means this means something else. Or you won't consider it. These are all decisions that you'll make as to why that's relevant. This whole case, the prosecution's case, and this goes to every single thing that every exhibit we're going to look at. It's not just about, did he have lunch? Did he eat lunch? Did he pay for lunch? I can't prove my case if that's the only evidence I put on. To prove my case, I have to prove the elements of the gift regulation. The elements require me to show, first, that this is a person who was subject to the Code of Ethics, that he was the director of administration, I also have to show that the vendor who gave this free lunch to Jim Thorson was someone who had a financial interest in the decisions that Jim Thorson was authorized to make as the director of administration. So how am I going to show that? I'm going to show it a lot of different ways. I could ask the other side to just stipulate to a lot of things, and I have, but we don't have those stipulations yet. So, you know, barring that, I have to prove. Jim Thornton was the director of administration. The director of administration has several divisions. One of those divisions is the DCAM division. The DCAM division has responsibility over state buildings and maintenance. The Department of Administration and DCAM working together put out a request for proposals to renovate the Cranston Street Armory. Scout, a vendor from Philadelphia, responded to that request for proposals. That was the proposal that was accepted. Scout and the Department of Administration entered into a contract together. While Jim Thorson was the director of, you see where I'm going, but so we haven't even gotten to lunch yet. But I need to prove every one of those things to you. So that you can decide whether or not there was a violation of the code. So as we go through every exhibit, I'll be happy to discuss why each exhibit is relevant to the things that I have to do as a prosecutor. So that's exhibit 3.
Right, I realize, Mr. Bristow, that it might not be appropriate not to at least give you the opportunity to respond. And in this instance, particularly to respond to the broader comments. But I will offer you that opportunity after each motion, because I think it's important to give you, as the proponent of the motion and technically bearing the burden on the motion, to, you know, get us to accept your position. And Max Wistow drops more papers than you did.
No rebuttal,
He's going to get,
and no, and the prosecution,
No,
no,
that-
you're gonna limit it at this
it's
point.
gonna be 1, 1, 2, and 1.
Fine.
Thank you. Yeah, I'm, my first remark is that I'm looking at, let's see, versus, excuse me, DePasquale versus Harrington. And it is an administrative hearing. It's on the RITT, as was said. And our Supreme Court cites the Administrative Procedure Act when it talks about when you can take evidence outside, accept evidence, when an administrative court can accept evidence outside of, the civil rules of evidence as they exist. And as we pointed out in our reply memorandum, that it is when it is necessary to ascertain facts not reasonably susceptible of proof under those rules. You know, evidence otherwise unadmissible, not admissible under the rules can be submitted. And it goes right on in this decision and addresses the issue of hearsay. But this is the prerequisite. This is the gate that it needs to be, that the prosecutor has to go through to allow hearsay evidence to come in. Because when the Supreme Court, as I'm reading this, you know, talks about hearsay, it says hearsay evidence is admissible in an administrative proceeding, but it references back 2 paragraphs earlier when it comes in. I mean, clearly hearsay is an incredibly important part of the rules of evidence in this state, civil or otherwise. And the case says, when necessary to ascertain facts not reasonably susceptible of proof. And there's been no demonstration of that. And that's something we pointed out and discussed in our reply memorandum. Secondly, and the council talked about all his obligations. I don't know how Exhibit 3 with a picture of Director Jonathan Homer, if I'm saying his last name right, proves that my client was the director of the Department of Administration on March 10th, 2023, or any other day. I mean, it's nice to stand up there and say, well, we have all these, you know, this is what I have to prove, and this shows it. No, it doesn't. No, it doesn't. And you know, Commissioner Centerini, I mean, this is some compilation of, without any cites, the statutory. I apologize.
That's no, you go ahead.
Go ahead.
I'm waiting till you finish.
Yeah, thank you. And in terms of what constitutes a public record, again, that's dictated by law. Okay, it's not dictated by the prosecutor or your executive director standing up and saying, well, it's maintained by the public, so it's a public record. I mean, if I work for the Department of Administration and I leave my cell phone at home and I use their email and I say, hey, you know, call a family member, my wife, and say, you know, is it on the kitchen table? I need to know, you know, is that a public record? Is public record is defined under the rules of evidence, rule 8038. I'm gonna, in 1 minute, you understand? I mean, I'm sure it's on a server somewhere into perpetuity, you know, but it's a record maintained by the Department of Administration, but it is not a public record as that is defined by the rules of evidence. 8038 as specifically as can be verbatim. records, reports, statements, or data compilations in any form of public offices or agencies setting forth the activities of the office or agency, that's A. Now, my calling home from my phone is not setting forth the activities of the office or agency, or B, matters observed pursuant to a duty imposed by law as to which matters there was a duty to report. And that goes on to excluding police reports of criminal matters. That's not my call home either. There's no duty under the law for me to make that call, to do anything, or for the office to keep that. So matters observed pursuant to a duty imposed by law as to which matters there was a duty to report. Okay, you look at the cases here and, that they're talking about, real public documents, things like, birth records and death records, tax returns and things like that, that are quote unquote public records. They're records that are required to be kept, and the person filing them is under a duty to do so, and to do so, I won't say truthfully, but truthfully and accurately. So that's what, you can throw around public records in terms of something that is kept as part of, or would become part of, a public cache of documents and things that happen. Again, referring to my phone call, my email home. I keep saying phone call, my email home, but it's not a public record under rule, the hearsay, which is that council references in its initial objection, which is 803.
Questions? No, I'll be last.
Okay, no, you go first. I had a
Go ahead.
question. Go first.
Sure.
I'm not a lawyer.
Sure.
So I hope this isn't disrespectful in any way, but if this document means so little, why are you fighting so hard to not have it included?
Because we have two reasons, and thank you for the question, because we have to have consistency in terms of what we're doing. You're gonna see that in exhibit 4, 5, 6, these, and I don't want to talk about what they are, but if you looked at them, you know what they are. I mean, are they, to me, they're virtually irrelevant. They're largely inconsequential to any decision that you folks are gonna have to make. But we have to make these objections so there's consistency. And secondly, and I say this respectfully to you, if this commission were to reach a determination that was adverse, to Mr. Thorson, I have to have a record.
Yes.
I have to say that, look, I didn't do this one, but I did that one. I have to have this consistency, and I have to make these objections. And then you folks, as the commissioners, have to make your determination as to whether, whether they're meritorious. But there's a little bit more to it than the immediate pending hearing on the 17th.
Commissioner Rapido, I think you had a question.
Attorney Bristow, no opportunity for stipulations that would save us some time and effort here?
I think we did stipulate to most of this in the factual stipulation, but there was two separate components to this, and I don't know to what extent the chair wants me to even.
Well, all I want to say at this point is, did you stipulate that he was the director of administration on March 10th, 2023?
I don't remember exactly. I can look at it, but the bottom line is, I think I did. Yeah.
You dispute that?
No reason. No, of course not. You asked me if I specifically stipulated
No,
that.
but
I received a series of stipulation requests from Mr. Grammett and went through them, and for anything that wasn't that I thought was immature, I agree.
But you understand the point of my question, which is Mr. Grammett's position is that it's relevant to show certain facts, including in this one, I think, that he was an employee on that date. And that was your point, was this doesn't show that. But my point is, are we really fighting about that? It's obvious he was the director of administration on that date. I can almost take judicial notice of it.
I think, and I can flip that on its head a little bit, and I don't want to. I mean, I don't mean to be disrespectful, but does Mr. Graham think for a second that Jim Thorson is gonna come in here and say, oh, no, I wasn't the director of administration?
That's not my question.
No, but it's.
No, but it's not, because my question goes to whether we should even have to consider some of these issues that could be easily stipulated to. That's my point.
Okay, and I believe that we have a stipulation as to that he was the director.
We don't have any stipulation, Chad. We have a negotiation over stipulations, but you haven't stipulated anything, and we're still in negotiations. I think
That's what I understood.
I need to clarify that. I have advised the prosecutor of his proposed stipulations that we do not agree with. Okay, I just don't have it right in front of me. Otherwise I could read it to you. What's the stipulation? Yeah, was he the director? Of course it was.
Why don't you stipulate that now?
Yes.
I don't have it.
I have a few questions.
Sure.
Something you said was interesting to me. So I saw you, read the De Pasquale case as handed to you. There's a few more in the line of that cases. I know Rhode Island, we don't have a ton, right, to go work with usually. But, I did do some digging on Westlaw, and found, a year later, the Dupree, Ethics Commission appealed the Superior Court. Again, revisited De Pasquale specifically as it relates to the Ethics Commission. And in that case, I'm not gonna ask you to tell me what it says because it's Superior Court decision, but it talks about, again, how hearsay evidence is the type of evidence that the Ethics Commission can consider. There's an even more recent case from 2004 about the Foster Gloucester Regional School Committee versus Board of Review, again, discussing De Pasquale at length. About how, what's the purpose of the hearsay exception, why it doesn't apply in administrative context. And so I guess I heard you say that that hearsay should be the gate, the threshold, and then maybe you could consider it. But I want to know, what do you have to do to get over that gate? So I'm trying to understand, you have to accept it, it's in front of you, you don't have to agree with it, but there are other cases that say similar things. I specifically work in administrative law, and so I know that hearsay is allowed in front of the administrative bodies I practice in front of. So I'm trying to understand what you think that threshold is you have to get over for the hearsay to be allowed, beyond just it's allowed.
Okay, and I think it's prescribed in Rhode Island General Law 42-35-10, that subsection A, which reads, when necessary, again, I'm not gonna read it for the third time, but when necessary to ascertain. And that is, to me, the gate threshold, that person who's offering evidence outside of the civil rules of evidence, which I think was described in the Administrative Procedures Act. That's what they need to demonstrate before hearsay evidence is offered and accepted. And if I'm wrong, then, then let me know, and it's not an intentional misrepresentation, but I'm telling you that, I have done other, not many, but I have done other, and nothing before the Ethics Commission, but I have done some administrative hearings. And, everyone kind of goes around, well, so there's, the rules of evidence are dealt with, they're relaxed, and they're dealt with more loosely. But, after reading the objection and looking at this, I think that's what the statute, it is what the statute says, and I know it's in, in the De Pasquale decision. Now, I don't know anything about the, the pre.
Let me tell you what it says and see if you want to respond. You don't have to, you haven't had a chance to review it. And again, it's a Superior Court decision, right? So, but it says that it allows 42-35-10, allows an administrative agency to consider hearsay evidence when it's a type commonly relied upon by reasonably prudent men in the conduct of their affairs. While admittedly a standard not capable of exact definition, it is nevertheless designed to afford an administrative agency the necessary flexibility to advance the public welfare. De Pasquale, citing it, so long as prudent persons believed in like situations would rely upon such hearsay testimony. Thus, a hearing officer may take into account evidence that would otherwise be excluded if it was prudent to do so. And it goes on to say that indeed, violations of the code of ethics would be unlikely to prove them without at least a modicum of hearsay. That's based on the nature of the feeling that there's likely to be hearsay involved. So again, what is it that you think that can be ascertained here without these documents? You said that it has to either follow the rules of evidence unless it's something that can't be ascertained outside.
Reasonably ascertained,
Yeah.
What does that mean?
Yes.
Yeah.
What does that mean to you?
Yeah,
how do we get there?
It means to me that there's one of two reasons. It's a matter of, it could be a matter of extreme inconvenience. For example, a witness who is unavailable, either because of geography or for other reasons. It could be
Like the witness in Philadelphia, perhaps.
I mean, this is a great.
Yeah.
And I don't know that I want to take it, but I want to answer that directly. I mean, is there a reason why that person, why either or both of those individuals cannot appear before this hearing? I mean, there's a statute that says they can do it electronically. It's recently, I think a year, more I do, but a year and a half ago, I mean, they can testify electronically. So if someone said, that or they could be subpoenaed, they can go, there's a process, as we know, and we did it in discovery in this case, before we accepted affidavits in lieu of a deposition where you go and you appear, before a court. But I mean, there has to be limitations that are, you're gonna see, you may have seen that exhibit 32 and 33 are affidavits from the two scout principals, in the case. And those were proposed by the prosecution, and we certainly had no objection to them coming in. But I guess my reaction to you is twofold. One, I'm just looking at this Steve Pasquale case. And I see how they go through the statutory language as it relates to what it is that the opponent of the hearsay evidence or the evidence that's outside of the rules has to prove, and what threshold they have. And what you're reading to me, and I said respectfully, I don't hear any of that language in there. If you're telling me it's not in the case, then it's not in the case. But I'm talking about the Dupree case or whatever.
It's citing Dave Pasquale, yeah.
Yeah, but, okay, but I'm just telling you what I read in this case, and that is the threshold of what I read in the Administrative Procedures Act as it relates to the threshold. And I think it's up to the administrative body to make a determination as to what constitutes not reasonably susceptible of proof under the rules of evidence. I sort of went off on when you talked about the Philadelphia witnesses.
That's okay, I have to.
Yeah, so it's, I mean, I would stand up here if the prosecutor in this case were to call their investigator and he would have said, oh, I talked to them and they said 1, 2, 3, 4, 5. I would object to that strenuously. I'd explain all the time that it had been, the windup they had here, the options they have to get these people here, including participating through electronic means. The body, I think, once there's some demonstration or a real demonstration, that it's, somehow not reasonably susceptible to proof by the rules of evidence.
So it sounds like, I won't put words in your mouth, but your threshold is almost like a best evidence rule, that we have other evidence, or there's other evidence out there that could prove the same things, and so, but for that, we can't bring in hearsay.
Well, in connection with document 3, I think it's accurate in terms of the larger discussion about the hearsay rule. I don't think that is the case. I mean, I think that, but as a body, folks are gonna decide, I'm not telling something, but you're gonna decide, what comes in, what's truly relevant, what is admissible under any relaxation of the rules, or whether or not our objections are even, legitimate under the rules.
One final question, and just, this might be too far adrift, so don't feel like you have to go too deep into it, but what's your take on the fact that, let's say, hearsay applies?
Yeah.
Wouldn't then it make sense that all commissioners on the Ethics Commission have to be attorneys who have had evidence and understand the rules of civil procedure? How does that comport with the fact that we are a mixed body of some practitioners and lay persons? How are the lay ethics commissioners supposed to understand hearsay?
I think they're supposed to seek guidance from their legal counsel.
Okay.
And I mean, certainly they can from any, there are 2 judges. Put that aside. Assume we have all lay people, but you have to seek guidance from your legal counsel. I say very respectful, but I think that's the only answer I have for that. Okay.
Good term.
The lay people on the commission, this is just as a side, may bring a higher degree of common sense. Those of us who were tortured by the rule of evidence, both in law school and in the practice of law. But now to a point that I'd like to raise. While the cited case of the prosecutor dealt with the admissibility of evidence in a civil procedure. A matter that I'd like at some point to be addressed is this body is very unusual. We are a constitutional body. We've been established by the Constitution. And the General Assembly, in flushing out our responsibilities, established by law that there's a presumption of innocence that's usually not found in a civil case. And what I am trying to come to an understanding of, does that presumption of innocence require a higher burden upon the state or the prosecutor than a pure civil case?
It's preponderance of the evidence. The burden on the prosecution is to establish its case.
I'm dealing with the admissibility of evidence.
Civil and criminal side, Judge.
I don't know of any case that's been addressed
Yeah.
that dealing with the Ethics Commission that has fully been flushed out, the presumption of innocence.
I think. The burden of proof. When we get to a hearing, is a preponderance of the evidence, even though there's a presumption of innocence. That's what the regulation of the statute say. In terms of admissibility. Again, it's case by case, item by item, and first we have to, if there's a question as to authenticity, the prosecution is gonna have to establish that the documents are authentic. The question is relevance, the prosecution's going to have to establish that it's relevant, and here's why. If there's an issue as to hearsay, the prosecution's going to have to establish why it's admissible pursuant to the Administrative Procedures Act and our regulation, and why it's relevant. So every single piece of evidence that's submitted for introduction, but it's not, the burden's on the prosecution.
And does that likewise apply to an allegation that something that the state is seeking to come in may be unduly prejudiced to the respondent?
Well, yes, that is going to have to be considered. Let me just, if I may, let me just, for the benefit of everyone, let's talk a little bit about relevance and hearsay, because we're talking about it in kind of a piecemeal fashion. Okay, let's just talk about relevance first. The Administrative Procedures Act of 4235-10 and Commission Rule 3.23 state that irrelevant, immaterial, or unduly repetitious evidence shall be excluded. Now, what is relevant evidence? Under Rule 401 of the Rhode Island Rules of Evidence, relevant evidence means evidence having any tendency to make the existence of any fact that is of consequence to the determination of the action more probable than it would be without the evidence. Under Rule 402, all relevant evidence is admissible, except as otherwise provided by state or federal constitutions or statutes or by the rules of evidence. Conversely, evidence which is not relevant is not admissible. Under Rule 403, although relevant, and this is what you were getting to, Commissioner, evidence may be excluded if its probative value is substantially outweighed by the danger of unfair prejudice, confusion of the issues, or misleading the fact finders, or by considerations of undue delay, waste of time, or needless presentation of cumulative evidence. Hearsay has also been discussed back and forth a little bit. What is hearsay evidence? According to Rule 801, hearsay is a statement other than one made by the declarant while testifying at the trial or hearing, offered in evidence to prove the truth of the matter asserted. Under Rule 802, hearsay is not admissible except as provided by the rules of evidence or by any statute or rule of the United States or Rhode Island prescribed pursuant to proper authority. Rule 803 sets forth the various exceptions to the hearsay rule, including subsection 8, which is the public records exception, which has been referenced. And there's also a catch-all exception in subsection 24, allowing for statements not covered by the prior exceptions, which have equivalent circumstantial guarantees of trustworthiness. I think Mr. Bristow is going to get into Rule 805, which is hearsay within hearsay. And under Rule 805, hearsay included within hearsay is not excluded under the hearsay rule if each part of the combined statements conforms with an exception to the hearsay rule. Now, as previously referenced, our Supreme Court has held, in the US Supreme Court, has held that hearsay evidence is admissible in administrative hearings. That's what we're doing. The Administrative Procedures Act at 423510 provides that the rules of evidence as applied in civil cases in the Superior Court shall be followed, but when necessary to ascertain facts not reasonably susceptible of proof under those rules, evidence not admissible under those rules may be submitted if it is of a type commonly relied upon by reasonably prudent persons in the conduct of their affairs. Now, the language in our Commission Rule 3.23 is consistent with 423510. Finally, let me just add that the Supreme Court has stated that the provisions of 323510 limit the sort of hearsay evidence admissible in administrative proceedings to that necessary to ascertain facts not reasonably susceptible of proof under the rules of evidence as applied in civil cases in Superior Court, if of a type commonly relied upon by reasonably prudent persons in the conduct of their affairs. So that's really a summary of relevance and hearsay and what have you.
Yes, I just certainly back to Commissioner Centarini and as a layperson who thought he had common sense until about an hour ago. At a minimum, 230 years, and I'm being very conservative, of legal expertise at this table and over on that table. And trust me, I'm being polite with that number. And we're on number 1. We're on Exhibit 3, and there does not seem to be any coalescing with our attorney professionals with what exactly hearsay is. Thank you, Herb. And what relevancy and so as a layperson, I would argue that we are trending in a highly technical direction.
Yes.
In terms of the reading of the statutes and what they mean and interpretation and then this application of charisma and a few other things. So I would just maybe ask the chair, what do you propose here? What do you see the next hour looking like? What is your thought process?
Fair point. First of all, what we've done for the last whatever half hour is had a broader argument, broader presentation of the positions of the parties. Much of that is going to just play right back through the rest of it.
Okay.
So I see those going relatively quickly now that we have had the broader discussion of what we're really looking at. And I emphasize again, Commissioner Callahan, that one of the choices is to defer and to spend more time considering how you look at this evidence, because a decision today is not a decision that it is admissible, and it really is not a decision that it is not admissible, because Mr. Brown is going to have to present those exhibits as identified exhibits. We're going to have to decide then whether they come in as full exhibits. Again, for the non-lawyers, documents go through 2 steps. One is they're presented and they're identified, so that's admitted for identification.
Then the question becomes, are they admitted as full exhibits, meaning they're exhibits that we consider in the deliberation? We can defer to make that ruling at the time of trial, since they do have to present the exhibits for the record. I understand the concern here, which is we'll be here till 4 o'clock if we're not careful. And I don't think anybody here, including Mr. Bristow, Mr. Kelly, and I know Mr. Grammett, don't want to be here till 4 o'clock. So I think it may be useful to us. I'll use 4:30 for Mr. Green.
You say anyway.
Until 4:30. We've had a useful discussion, and I still think we need to talk about each item. Unless folks here feel that we've heard enough generally to be able to speak to the kinds of exhibits we've been presented, or if one of the commissioners has a broader perspective on what we could do today. And I see Commissioner Rabbit has a thought.
Well, my thought is that the parties should get together and work on the stipulation, going back to, Commissioner Callahan. If the prosecution has given stipulations to the respondent and the respondent has some thoughts about them, if you can whittle this down, maybe we should be deferring some of these and forcing them to do that.
Commissioner Brown.
I have a question, just speaking to what was said earlier about, just for example, exhibit 3 and its relevance. I wonder how many other exhibits in this binder could also be determined or could have the question raised about their relevance. And I'm just wondering how long that would take, and just using the example of the first exhibit that we saw.
Well, the respondent is claiming in its motions and in its reply that many of these exhibits, so most of them, are not relevant. Or even if they are relevant, should not be omitted because they're prejudicial or they would lead to confusion, as set out in Rule 403. So in all of these exhibits, as I understand it, correct me if I'm wrong, there are objections based on relevance or hearsay. Or if it is relevant, it's unduly prejudicial.
We may also be faced with the situation where if we do vote after each presentation response, it's certainly within the province of the respondent to appeal that forthwith.
No,
I suggest
no,
I'm not, the Superior Court, the only redress they'll have is the Superior Court chair.
at the end of a final
Oh,
judgment.
well, again, that's the point I'm trying to make. If we're gonna exclude evidence, and they feel that evidence should not be excluded in order to proceed with their case, they can go to Superior Court, have that addressed.
No, they cannot.
Oh, yes, they can.
Well, let me just say,
Let counsel speak.
let me just say that, they cannot go to the Superior Court to appeal essentially until we've finally ruled at the end of the evidentiary hearing. Okay, but certainly, I think this is what you're getting to. If evidence is excluded and not considered by the commission, that is a grounds for appeal. Which would be raised by the respondent, but it would be raised at that time. After the hearing, after a decision has been made, after the written decision has issued.
And this, if we vote to exclude or include, as the case may be, and they feel that at that point in time, that inclusion or exclusion is really a detriment to their case going forward, they have to seek. What other redress would they have?
Commissioner,
Superior Court is the only avenue they have.
They do not have the authority to appeal anything other than a final decision of the commission. And at that point, if we've committed error, they're gonna get us reversed. But right now, they cannot appeal.
They can seek a stay, clearly seek a stay, Chair.
Commissioner, I don't think we need to go back and forth because they're not talking about an appeal.
I'm just throwing this out.
I understand, I don't agree with you, I guess I'll leave it at that.
Okay.
I have a purple, I mean, let's put this in my proposal. I'd like to hear what you have to say about the rest of the exhibit. So I think we understand your argument about hearsay as applied to all of them. The rest of your arguments are either relevancy or unduly prejudicial. Could we ask that the respondent talk to each item, why it's either irrelevant in his opinion, or why it's unduly prejudicial, and then here's Director Granite, and then
I'm fine with
Wrap
a
it up.
fluid approach, so let's do that.
We've heard about hearsay. We understand both party positions on hearsay. I don't think they need to, I don't personally need to hear again, both sides' positions on hearsay.
And I appreciate that, Commissioner Peterson. I think that's a good choice. And now, Mr. Grammett, Mr. Bristow was up for quite a while. But I think in light of what's being suggested, that we'll let him get back up again and talk about which one you want first, Mr. Peterson?
Keep going down the line,
Unduly prejudicial.
or either relevant, and then I guess I would suggest, I mean, you put your argument how you want, like,
Just those two, we're done with hearsay, so you're suggesting.
in
at
my,
this point now.
yeah, from my view, I don't know if anyone else needs to hear more about hearsay from the parties, but.
Every argument.
Right, that's why I'm saying maybe don't, because we've heard it applies across the board. We'll see.
Right, yeah, I mean, so what you want me to do is go forward and just in the briefest of terms, address these things. Good.
I think what Commissioner Peterson is suggesting is a broader argument, which is explained to us. Yeah, there are certain ones you have on the unduly, prejudicial. But I think her real question to start with, and I'll jump, is what is relevance? Why do you say they're not relevant? And frankly, that flips the coin in some ways. You've made your argument in your papers. It's really up to, on relevance, in my view, it's really up to the prosecution to establish why they're relevant. Now, Mr. Grammett has given us a broad statement earlier about why he thinks they're relevant. And I do want to comment, Commissioner Rabideau, that it may well be that the stipulations are still insufficient for the prosecution if they can't get agreement on certain things. Mr. Grammett is suggesting that while it's about lunch, it's a much broader picture that needs to be presented.
But he also suggested that, he had to lay the foundation for the respondent as one, the director of administration at the time, two, the director of administration's responsibilities and his job. And those to me it seems like that's part of, his evidence that he's putting in. And if they were stipulated to, we could knock some of these out of the ballpark to go to your baseball analogy. We just take them right off the field. So again, that's common sense to me, but I will sit here and deal with each one if we need to.
Okay, good.
Parties, I think, have greater flexibility on whether to enter a stipulation or not than requests for admissions. I mean,
Respectfully, it's too late for requests for admissions at this point, I would suggest, because I think that would be outside the context of the discovery that's been done. I don't think there's enough time, frankly, to deal with the request for admission. And I don't think that Mr. Bristow's a professional, Mr. Kelly's a professional, Mr. Grammett's a professional. They're gonna do their best to reduce the scope of this trial, and they know why they're gonna do that, because they don't want to put us, as we are right now, into a position of going, gee, are we gonna be here all day? Now, the trial's a different story. We may well be here all day for a trial. But I think right now, what Commissioner Peterson is suggesting is that the parties address the broader points, you've established, you've discussed hearsay at length. Let's hear something on relevance. And let's hear something on unduly prejudicial to the specific ones that applies. Is that what you're suggesting, Commissioner?
Yeah, just if there's specific call outs you can make for, I understand your arguments. We've read the pleadings. If there's specific things you'd like to highlight for those two overarching objections, or call our attention to, that's what I suggest we do down the line.
All right. Yeah, I think there's a lot of very interesting things. Let me just go through this. Let me get the ball
Sure,
in
I
this
just-
direction.
Yeah.
I just
Okay.
want everybody to understand it is not Mr. Bristow obligation to establish relevance. He's establishing what he doesn't think is
Correct.
relevant.
Correct.
Just
I
so
wasn't
clear.
suggesting that.
Exhibit 4 is just a job description, again, undated, from the Department of Administration for the position of the division director, the DCAM. And I will concede that that is the position that David Patton held during the relevant time periods here. But again, there's relevance is what I'm gonna argue here. I don't think this, I don't know when this was created. I don't know if it changes. I don't know anything that would cause this body to have faith that this is a true and accurate that this was in place at the time that's relevant, which is the screen going into 2023 for that. So I don't, I just don't think it's relevant. Don't know when it was created, so relevance, duly prejudicial, no, doesn't seem like it to me. There's nothing, right? Exhibit 5, which is just a RFP put out by the state for the Cranston Street Armory. Again, it's a proposal. It's dated June 12th, 2020. And it's, it's up to you folks. How far do you want to go back? Is this relevant? Is this something that's a prosecutor that you need to hear, or the prosecutor needs to prove for you to have, to be able to make a determination regarding my client's conduct as it relates to the ethics rules and another statute in this case. So I would argue to you, it's not relevant, okay?
But you don't find it prejudicial, is that correct?
Oh, no, it's realistically, no, there's nothing prejudicial about it.
You got some that are based on prejudice, you get to those.
Yeah, very much
And
so.
I don't think we need to exclude each one as we go. He's trying to go, he's gone through hearsay for pretty much everything here. He's gonna argue now relevance to the ones he's truly concerned about relevance on.
Yeah,
And then if there's undue prejudice on some of these, which I think there's at least a few, he'll argue why.
and again, I'm looking at exhibit 6, moving on to the scouts proposal for pursuant to the RFP for the Cranston Street Armory. It appears to be dated just a month or two later than the RFP was June 12th, 2020. The scout proposal was July 15th, 2020. I would argue if it has any relevance, it's truly minimal. Exhibit 7 is the agreement that the state entered into. I can't find the date on it with Scout relating to do an initial assessment and perhaps provide some other services to the Cranston Street Armory. I just would argue that if this has any relevance, it is minimal. These are all dozens of pages long, and if you think they're an important part of it, then they're relevant and worth considering, then it should be that. Exhibit 8 is Scouts, something to do with Scouts invoices to the state, seem to begin in July of 2022 and move forward. There's hand notations, there's an email exchange between a Scout representative and 2 state representatives, one of whom is David Patton. Nothing to do with the trip to Philadelphia, nothing to do with lunch, nothing to do with anything in that context. So I argue it's minimally relevant, if it's relevant at all. Your determination, it's 25, 30 pages. Exhibit 9. There is a January 3rd, 2023 email communication between the Director Thorson and one of the principals, Mr. Abitbol.
Before you go further, your motion says 2022, December 2022. And if that's correct, I just want to make sure the record's correct.
Okay, just give me 1 sec. We're talking about exhibit 9 now. Is that right? Sure.
Yes, exhibit
Okay.
9. Emails regarding a December 2022 meeting between Scout and representatives of the school. It's all right. Sorry. I said
That's
that
what
wrong.
they're discussing, but the date of the email, it appears to be January 3rd, 2023.
All right. Thank you.
but this stuff, and I say this respectfully, I'm not trying to speed the whole thing up for anybody's benefit. But, I mean, this is brief. I mean, we wrote out what we thought and why we thought it. And I seem to be going through these things, so please don't take any meaning with that I don't think that in their aggregate, that it's not important. Okay. Exhibit 10 is then emailed between David Patton and someone else, I think at the Department of Administration. It's copied to my client. It just discusses some details relating to the state of January 5th. And I just don't, again, with the hearsay moving forward, I just don't, I think it's marginally relevant if it's relevant at all. It discusses some interaction in state government regarding the armory and budgetary considerations and other things. So, you know, this is like exhibit 11. It's an email, sent on apparently January 26th of 2023. Had nothing to do with the visit to Philadelphia. It has nothing to do with the lunch. And it's from somebody at DOA named Jonathan DePault to the two principals at Scout, and David Patton's copy. My client, I mean, what relevance does this have unless there's some demonstration that my client saw it or they knew about it? He's not copied. I mean, that's where you need to, I mean, get into this. What possible relevance does it have to your consideration of my client's conduct on March 10th, 2023? Just think it does. What is it? Exhibit 12 is interesting, and Judge Centerini, excuse me, you know, raised this. There's a series of emails that go between January 5th to February 9th, 2023. Again, nothing to do with the trip to Philadelphia, the lunch, anything that's material in that way. It seems to be about bills and invoices, and this is the one that's, you know, that's redacted. And I'm gonna, if you don't mind, folks, I know you're all right, but I mean, it's not, this stuff here is just who should go into and the confidentiality boilerplate language, but the substance of this, you know, is largely redacted. And I think it's objectionable for something we haven't discussed yet, although it is in the reply memo, Rule 106, the doctrine of completeness. I mean, this is, you can't give someone something and offer it as an exhibit and have it not be complete if it's a recitation of individuals thinking. Now, my client is copied on this, but he's one of 9 people who are copied on this email. And again, it deals with billing with stuff in the state. And that's relevant for what my client is alleged to have done, then make that determination. That's where we are. Exhibit 13. Was you counting them? This is 10 so far we talked about.
This is number 11.
This is, no, I'm on exhibit 14.
Are you talking about exhibit 13?
It is exhibit 12. I just spoke about it. That's the one that has the heavy redaction on it, okay?
That was your 10th motion.
Yeah.
Okay.
Yeah.
All right. Thank you for correcting me. Exhibit 13, I think, is, it's an email from, Abbott Ball, one of the principals of Scout, to Patton. Hope you had a nice weekend. Circle back. Meeting with the governor and his team, which you said you were gonna schedule. Be helpful for us to touch base thereafter to talk about the budget amendment, if it's forthcoming or not. Please confirm if this time talks to you, if this time works for you. My client's name not on here, it's got nothing to do, you know, it's not copied, it's not anything to do, it's not an author of it. And it has nothing to do with a trip to Philadelphia. Exhibit 14. Which is an email from Patton to Abbott Ball and to the 2 principals of Scout. Again, it is not, my client is not copied on it. And Mr. Patton talks about having a great conversation with the governor. Dozens of other things. It's all about, you know, the state moving forward with this Cranston Street Armory project. So, Exhibit 15, same thing, it's dated March 8th, 2023, so it's close in time. But it's an email from a person named Danielle DeMiro, who was writing to two folks at the DOA, Sandra Schenk and David Patton. And it talks about Scout invoices. I assume Danielle DeMiro is an employee of Scout, and she's writing about some invoices. Exhibit 16. This was, I'm sure I have this right. I appreciate your patience, thank you. This is a second email also sent on March 8th, 2023. From David Patton, sends it to my client. And 1 second, please. Yeah, so March 8th, 2023 email, excuse me. Well, initially it's a chain, but the top one is from David Patton to my client. And it talks about some interaction that Patton's DCAM is having with Chris Farrell, who I think you'll find out works for the government or something like that. Can't tell you, I studied this, I did read it, and I don't see anything in it in any way relates. I find it's common, so I would argue too that it's a relevance issue. Just give me 1 second. Exhibit 17, April 7th, 2023, so it's nearly a month after this Philadelphia visit. It's an email from my client's chief of staff, Libby Kimsey, to a person at Scout, this Danielle DeMuro again. And they're just following up on issues related to billing and contractual obligations the state might have with Scout. Nothing in there about lunch, nothing in there about visit, nothing in there. So, but that's what it is. So I don't know if I could call that exhibit 17. Okay, yeah. Just give me 1 second. Exhibit 16, I think I skipped.
No, that was 17.
I'm sorry?
Yeah, that was 17.
Did I address it?
Yeah.
Okay. Now, exhibit 21 is nearly identical to exhibit 31. I think it is, let's call it identical because that's what it is. And this is the exhibit where I'm going to talk to you about unfair prejudice because, and we'll call it hearsay within hearsay, and you know, you said it could be admissible, or your legal counsel said it could be admissible within the context of the reliability of what's asserted in the hearsay. If I got that wrong, you know, but that's
Correct, but as to each hearsay statement.
yeah, right, yeah. I mean, look, basically, after the visit, there's a, well, let me tell you, my objection to this is, first of all and foremost, hearsay, okay? And that's, and you don't want to hear that again, but you have to hear that in connection with this document. Relevance, okay? You know, this is not addressed to my client. There's no evidence that I've seen that this, certainly that there can be at this point, appended to this, which indicates that my client saw it, that it was shared with him. If you compare the substance of the hearsay within hearsay, this is Scout's lobbyist sending to the governor's office an email that he received from the two principals at Scout. And if you compare what they wrote in that email with the exhibit 32 and 33, they're affidavit, you're gonna find this material contradiction after material contradiction. You know, I assume they were just angry when they wrote it, I don't know, but the bottom line is, they did this and they did that, and they are responsible for this, and they were unprofessional, you'll see it, okay? And you have this stuff, you've read it, I know you're all intellectually honest enough to ignore it if you decide that if it doesn't come in. Then you read their affidavit, and they weren't talking about Jim Thorson, okay? They weren't. You know, there's a couple things they had to say about Thorson, but Mr. Thorson, but they, you know, what is in this email is unfairly prejudicial to my client. And it is directly contradicted by a sworn statement that you have before you in exhibit 32, 33. And
We don't have 32 or 33 doing.
oh, you don't have,
No,
you don't have
have
that
that
yet,
yet.
because you don't have all of them, you have
Correct.
what was objected to.
Correct.
Well, you can accept my representation, and if you want to defer the decision on this until you hear the context in which this is offered, that's fine. But the bottom line is, I'm representing to you, that it is materially inconsistent with the sworn statements of these folks in their affidavits, which are exhibits which have been assented to by both sides as being admissible before you. So I don't know, it's not the author. I don't, it's hearsay within hearsay. And it's extremely problematic from the prejudice perspective, and I'm repeating myself, and I'm sorry. Okay.
You also indicated in your motion that it's irrelevant and confusing.
Well, it would seem, right? Yeah, I mean, and again, without going into it and based on what I've represented to you, and I don't know if it's proper for you to accept these representations at this time, but it's my argument to you, and it's what the facts expect will be established. You will see established here. Exhibit 24, which is the next one. I think it's not authored by my client. It's a series of text messages sent to my clients. On March 9th, and on March 10th. And again, I'm going to say to you that unless the prosecution, unless and until the prosecution can establish, if my client saw this at some relevant time related to that trip to Philadelphia and that lunch, that it is not just irrelevant. It's not relevant. There's no response by my client, and I just don't see that. The relevance, basically.
Can you state for the record the date of that lunch and where it took place, please?
Sure. The date of the lunch was March 10th, 2023. Exhibit 24 are a series of text messages, 4 of them that were sent to my client by. You're gonna learn, I'll say it to you, but by Libby. And I'm gonna forget her last name. Yes. That would they started the evening before, the first one is March 9th, and then the rest three on March 10th, which is the date of the lunch. Okay. But in my, again. And I said this respectfully to you, Judge, he's, the client is not the author. So again, try to be very selective about saying it, that this is hearsay. And I have said that unless there's a demonstration that he saw, received these messages at some time relevant to the conduct that's alleged by the prosecutor in this case, that it's not relevant.
So your only concern is the lunch that took place in Philadelphia, not the lunch that took place here at the Capitol building?
Yeah, this is very respectfully, I think if you were to look at the complaints here, the allegations, it all involves March 10th, 2023. In Philadelphia.
Certainly that, Attorney Bristow, to exhibit 21, you're citing hearsay within hearsay, is that simply because it was forwarded email, or how are you determining it's hearsay within hearsay for that?
Because the person who sent this email didn't send it to my client, so there's one level there.
Yeah.
And he is sending the factual component, the principal component of the email is something, is a statement that's made by another person to him or people, which is, I think it was actually sent by Abbott Ballmer. So, there's a court statement which is being offered, I assume, for the truth of the matter that's contained therein, which is the definition of what hearsay is, okay, by Abbott Ballmer. And that goes to their lobbyist, this guy Jeffrey Britt, and Sam, okay, yeah, you understand, so I don't need to keep layering it forward, because then it goes to the governor's chief of staff, and then there's gonna be some argument, I suspect, that it went to my client, but that is just, that's hearsay. Did I answer your question? I hope so. Hearsay within hearsay. Okay, exhibit 26 is an email that takes place 2 days after this lunch. It's just about 8 o'clock at night. It's on March 12th. It's between my client's chief of staff, and it relates to information that they have received by other department administration employees. And I'm going to argue that whatever, I'm going to argue to you that this is about this, it's hearsay, it's not open, when it's not. Yeah, it's not open. It doesn't involve the lunch, it doesn't involve the trip to Philadelphia, certainly not direct. But exhibit 27 is again sent on March 12th. It's an email from my client to Pamela Mascarelli, who I think is the head of the Department of Human Resources, the state, possibly from the Department of Administration. And his chief of staff will be Kivitz. An email chain, and it relates to my client's plans to respond to complaints that have been received. Well, David Patton from Department of Administration employees as a result of Patton's conduct, not in the Philadelphia trip, but the day before, which was March 9th. Argue relevance. Exhibit 28. Is where it is, I'm sorry.
Text message.
Yeah, text messages between my client and Chris Farrell regarding the March 10th trip. And I just don't see anything in here. It's a text message. And it's dated a week before the trip took place. And it's my client advising this gentleman at the governor's office that he and David Patton are going to go see March 10th week there. So it's relevant. I think it's marginally relevant because the content is, I don't know what it shows, some groups it's relevant. I didn't know this questions that I have to decide. The exhibit 29 are text messages between my client and again Christopher Farrell, and it relates to the March 10th trip. It doesn't make any reference. My client talks about his impressions, the facility that they toured, this guy had renovated, it was now operating, and his recommendations. So he includes, I think so. When he includes some photos, he does include some photos that he took during the March 10th trip. Doesn't have anything. I don't think it's relevant, and but it's here. Okay. And exhibit 30 is Dave Patton showed up for work on Monday, March 12th. He had written up his assessment with some photographs of the trip to Philadelphia, specifically as it related to Scott's ability to move forward with the Cranston Street Armory project. Again, suggest to you that this is it's not all. I mean, I think the allegation, as I understand it, It's that, and I have to say this, I'll read it, but is that, my client failed to do a statutory duty in pursuant to a code of ethics profession before it. The time of the luncheon, certainly the time we got on the plane, the leave relevant. You start looking at things that are dated and have to, and there's some last feelings of what's happening. I think they're relevant, I just don't think they're relevant, I think decision making, but they have gone on. Yeah, that's my understanding of what the allegations are and what the prosecution is.
Can I just ask a point of clarification? I'm having trouble finding it. Is that the exhibit where Mr. Patton claimed that he bought gifts for his family?
Yes.
Yes, it is, Coach. Yeah, it is. Okay. And again, I say this very respectfully, you know, at least you'll see they're out here in which we're going to differentiate Patton's conduct, my client's conduct, and we're certainly let's say this. We're going to focus on the lunch, which seems to be a violation. Good, thank you.
We're gonna focus on, I mean, I'm afraid that might not have gotten picked up.
Yeah, I'm sorry. I said, we're gonna focus on the lunch. Yeah, and that seems, is, everything I read is, you know, this is what they're claiming Director Patton, Director Thorson, you know, did wrong here and did in terms of what he did, it was fine. But the code of ethics and some of the statute. Okay.
Anything else
Questions? Let's
before
answer.
Any questions before we let you?
So I only heard, sorry, did you do 31 or no?
I did a 21 and 31 at the same time.
Right,
I'm
okay,
sorry.
great, sorry,
Because I
and then-
could be there identical.
The only one I heard you make oral argument or discussion about unduly prejudicial was
21, 30.
21.
Yeah, 21 and 31.
Okay.
And if I didn't make that clear, I would have,
I just want to confirm I have my notes correct. Great.
same arguments if you want.
No, thank you.
Thank you.
Any other questions before Mr. Briscoe steps down? All right, gonna give Mr. Graham an opportunity to respond, and I do appreciate Commissioner Peterson, your focusing us on this and avoiding going through each one by one, argument, response, argument, response, which is what to me is great. Would you like to take a break? We can do that anytime, Commissioner Ritchie.
Canvas will ask, make sure I'm not offended.
Camera will still get you if
Yeah, I got my
you.
money worth. Still.
But if anybody wants to step out, right, just let me know, because I can understand that. All right, Mr. Graham,
Thank you. Okay,
we're not gonna discuss relevance, right? You've done that. Is that where we are?
I
No, I
I'd
think.
like to hear.
I think he needs to discuss that.
Okay,
Yeah.
on each one, yes, correct.
Hold on.
okay, thank you. So I will go through each one, you know, my 30-second overall comment before I get into each one is just to remind you the context of this, which is this adjudication is in exactly 2. Right, so I'm the prosecutor and it's my burden of proof in this case, so I have to prove my case. And so these are the exhibits that I'm using, you know, among other things, to prove my case. But as of this moment, we don't have agreed stipulations, we don't have agreed exhibit, so this is where we are. I also want to say that it's clear that there's a difference between rules applying to a jury, applying to an administrative agency and its hearing officers, which is what you are. Hearsay rules are designed to not confuse lay jurors. There's a difference between what the judge allows in and what the judge allows the jurors to hear. But this is more akin to a bench trial, okay? So also, finally, the last thing is we go through these exhibits, I just want you to keep this part in mind, which is I want you to see every exhibit, including their exhibit. The affidavits that he's mentioning, that are their Lindsay Scanafio and Everett Apple's. I put those in, even though they're not necessarily favorable to my client, but I figured they would want them, and so I added them into my exhibits, as I will add any exhibits. So I just want to clarify the opposing circumstances here. Happy for you to consider everything, and then decide whether it's worth any weight at all. Not trying to keep anything for the consideration. That said, I've already discussed exhibit 30, but I can just briefly mention that I believe it is relevant because it shows what the role of the Department of Administration and State Government. It notes that the director is the head of that department. It notes that that department is responsible for all of the divisions, including the DCAM division, which is an issue in this case. So it is to look at the relevancy rule, right? Rule 401. This page then is probative of a fact that's of consequence to this case. And that is responsibility of the director of the Department of Administration. Exhibit number 4, which is the job posting that David Patton, who became the director of administration, applied to, is very relevant. And as far as, where it was, it's got a date on it. It's dated February 21st, 2022. If you look at the statements, why is it relevant? Why is this relevant to what I have to prove? Right in the very first line, to be responsible for assisting the director of administration. So it shows the chain of command here. In the next paragraph under supervision received, you see it says works under the administrative direction of the director of administration. So this is probative of the director of administration's role in everything that the DCAM director does. And DCAM, which is the division of DOA, dealt with Scout, who is the vendor that thought this lunch. Exhibit 5 is the RFP that the State Department of Administration put out that Scout eventually responded to. And of course, it's relevant. If you look at the very next page of that exhibit under introduction, it says the Rhode Island Department of Administration Division of Purchases on behalf of DCAM is soliciting. So this is a DOA solicitation for a vendor. The respondent is the director of DOA. Again, I have to prove that Scout, this vendor, had a financial interest in decisions that Jim Thorson was authorized to make as part of his public duties. The fact that this RFP came from the agency he leads is very relevant to that. Number 6, this is Scout's proposal in response to the RFP. Again, remember, all of these documents are authentic. These came from the Department of Administration. I asked for documents relevant to the contract between Scout and the state of Rhode Island, the Department of Administration. This is what they provided. They've certified that these are true and accurate copies of documents that they maintain. So the relevance of their proposal, well, it's relevant to show what they said they were going to do. This is what we're going to do in our proposed contract with the Department of Administration. Jim Thorson led that. Exhibit number 7. This is the agreement. This is the contract that Scout has with the Department of Administration. It made almost $500,000. It's a $500,000 contract that Scout had with the Department of Administration. Right at the top of it, it shows who the agreement is between. By and between the state of Rhode Island, Department of Administration, State, and Scout Urban LLC. Those are the parties. So that's very relevant in trying to figure out whether Scout thought that it had a financial interest in decisions that the director of the Department of Administration made. You can look at the signature line on that exhibit also and see that on behalf of the state, it says State of Rhode Island, Department of Administration, and DCAM. That's who the parties are. Exhibit 8, the invoices. These are highly relevant to that issue of whether Scout had a financial interest in decisions the DOA director made. These are the $400 and something thousand of invoices that Scout sent to DCAM, a division of DOA. It also becomes relevant because, as we will find out later, and I will put evidence on, the state wasn't paying Scout's bills on time. Scout had, some of these became open invoices. So at the time of the lunch, one of the things that Scout had an interest in was getting its past invoices paid, because the state wasn't paying the invoices on time. And who better to lobby for those than the director of the Department of Administration? So these are all the invoices that Scout sent. Exhibit 9 is an email stream, and here on the very first page, you see one is from Director Thorson to Everett and Lindsay, telling them, responding to Everett's email regarding an important meeting that they had. So this is important to show that Thorson isn't just saying Dave Patton is the only person who ever dealt with Scout, even though that would have been enough since Dave Patton is his subordinate, direct report subordinate. But here we have the respondent. You read this, you know that he had interaction with Scout also. He didn't just leave it to others. And if you look at the second page of this exhibit, this is where Everett is saying to Director Thorson, I speak for both Lindsay and I, these are the Scout principals, when I say thanks for providing the forum with the governor's team. They're thanking Director Thorson for providing a forum, and they're thankful for his advocacy. So Thorson is involved in Scout's dealings with the state of Rhode Island, highly relevant. Exhibit 10, another email, this one from David Patton to Chris Farrell with CCs to Jim Thorson and his chief of staff, Ruby Kinsey. Why is this email important? Because here's David Patton telling Chris Farrell that David Patton will support. Let me be clear, I will support whatever decision is made by Director Thorson and the governor's office. So this shows the level of decision making. That Director Thorson had. And that's one of the elements. Did Scout have an interest in decisions that Director Thorson was authorized to make or participate in the making of as part of his official duties? He was authorized to participate in the decisions regarding Scout. This email is probative of that fact. So is that determinative of that fact? This is a really important point here to make. No, it's not determinative. You may find that there was some hyperbole. You may find that it was inconsistent with some other exhibit that they're going to offer when we get to the adjudication. But it is at least relevant to this issue. It's something that a reasonably prudent person, to go back to the standard of evidence in the administrative proceeding, something that a reasonably prudent person could consider and rely upon in the course of everyday life. That's the standard for determining whether you can consider something. Going on to exhibit 11. This is an email from a DOA employee to Scout with Patton in the CC. Why is this relevant? Because it shows that very close in the time leading up to the lunch, DOA and Scout were negotiating a contract extension of that pre-development contract. That had ended. They were just getting their $25,000 a month payments at that time. But as these exhibits will show, at this same time, Scout is negotiating a 6-month extension of that contract for more $25,000 a month payments for another 6 months. Again, a financial interest that they had. Exhibit 12 is more to that. If you look at the second page of this email, it's an email from David Patton to Amanda Rivers at DOA, showing exactly the state is considering moving on to the next phase with Scout. And it's talking about the contract. So you can see Scout.
May I ask a question about 12?
Yes.
When you received the certified copy from the DOA or wherever.
Oh, this is the redaction.
Yeah, did they give you a sheet explaining the redaction? For claim privilege? I see that it's from some kind of legal services.
Here's my memory
They did
of
anything like that.
what this one was. No, I don't think I got or asked for a privilege log.
Okay.
For that. One of the things that I asked for from the DOA was, I want you to give me, please, your response to everyone's APRA requests about this issue. So they got APRA requests from Kathy Gregg and Eli Sherman, and APRA requests themselves are
Right.
public records,
Mhm.
as is the response to those APRA requests. So I'm pretty sure the reason this is redacted is because it came from one of the state's responses to someone's APRA request. But even though everything's a public record, under APRA, some things are confidential, and you're allowed to redact them if they maybe would have personal information about someone.
Can you just explain what a privilege log is for everyone, since you referenced?
Sure, a privilege log is where, when you ask someone for a document and they say, I don't have to give it to you because attorney-client privilege or some other type of privilege, then they at least have to provide you with a log that says, well, this is what it was that I'm not giving you. It's an email and, it's dated this date and maybe even who it's between. But I'm not going to give it to you because there's the attorney-client privilege. And if you want to challenge that in court, at least now you can identify what you didn't get. Anyway, this exhibit honestly is not all that super important to me, other than it showing these contract negotiation extensions. I would be happy, again, if I could get stipulations that said, if they'll stipulate that at the time of the lunch, Scout was actively negotiating a contract extension, then I don't need to put it in.
Excuse me, did you say number 12 was
Yeah.
not that important to you?
Well, I mean, they're all important.
No, I understand. I just wanted to make it.
Thank you. I'm sorry, I probably shouldn't have said that. I regret that. That I did utterance. The exception to do something. No, let's not remove it. Let's keep it in there. I'm gonna keep moving fast now. Exhibit 13 is an email that talk from Everett Abbott to David Patton.
I'd like to stop you for 1 second.
Yes.
Dr. Bronner has a family obligation that requires him to leave at this moment. He has sat through this much of the hearing. He's gonna not be able to vote on these today, obviously. That will reduce our voting element by 1. And, I expressed to him that I understand that he needs to go, I don't think he necessarily thought this meeting would go this long, but it is what it is, so Dr. Brown is gonna have to leave us. And that's fine.
This would be a good time to mention to all of us here that when the trial starts, if we don't attend everyone, then can't vote.
That's correct.
Does that apply to preliminary?
No.
No, that's the trial.
No.
No,
Just
the
the-
trial itself.
That's the same we did with the. Wait, see, there's a usual thing and just.
So commissioner to vote at the conclusion of the hearing. That commissioner has to be present for the entirety of the hearing.
That's what my understanding was. Right now, the record.
All right.
Back to you.
Great. Exhibit 13 is an email from David Patton, from Everett Abbott to David Patton. Why is this relevant? The second paragraph. Everett is asking Dave Patton, could you touch base to understand if a budget amendment is forthcoming? Or the alternatives, if not, because this, as of February 20th, the master contract had not been put into the state's budget. And so one of the financial interests that Scout had at this time was David Patton saying that the governor's office could float a budget amendment that would fund the multi-million-dollar contract that is at stake here. Get more of that hopefully later. Exhibit 14. An email to Scout from Dave Patton. That notes that he just had a great conversation with the governor and other leaders. They're reviewing the financial model. I am driving this effort largely at the direction of Jim Thorson. Echoed by Libby, Jim Thorson's chief of staff. And then they talk about that they're going to do a financial review. Chris Farrell and Director Thorson will relay this to you in their own words tomorrow morning. Again, so this is all relevant to show that Dave Patton is acting at the direction of his direct report boss, the director of administration, as to these issues with Scout. That Jim Thorson is involved with these issues. 15, this exhibit is an email that shows that on March 8th, which is one day before the lunch, 2 days before the lunch, excuse me. Scout is complaining about unpaid invoices. So Scout isn't being paid what it's supposed to be paid under its existing contract. And that's the state of things as this lunch is going on. Again, Scout has a financial interest in getting the director of administration to pick up the phone and say, why isn't Scout getting paid? Why are they overdue? Exhibit 16, an email from David Patton to Jim Thorson, or from Jim Thorson to David Patton on March 9th, the day before the lunch. Noting that Chris Farrell doesn't have the authority to set the scope of the financial review of the Scout contract. Do not take direction, Dave Patton, my subordinate. This is clear supervisory direction. Do not take direction from Chris Farrell. This is a major all caps problem. Jim Thorson. So again, this is probative of Jim Thorson's decision-making role over Scout, over the financial review that gets ordered, and of his supervisory control over David Patton, who is the normal day-to-day contact with Scout. $17. Is that one of the exhibits? Yes, it is. This is a long thread, and I only included every page of it for completeness. This is how it came to me. I'm not trying to hide anything from you, so I included the whole thing. But really, the one that I care the most about is about halfway through. There's an email, the thing I care the most about, from Jim Thorson, Lindsay and Everett, letting them know a few things. This is March 27th, so this is after the lunch. Dave Patton's on sick leave ever since the trip to Philadelphia. They hired JLL Consulting to help with due diligence. He's leaving DOA. Most importantly, a check to Scout's fees is expected to be cut. So they still hadn't gotten paid yet, but Scout, we're gonna pay you. And I'm the one who's letting you know that. That's the role that Jim Thorson has relative to Scout, to let them know about that. It's probative of the relationship and the decision-making of Jim Thorson in this issue. 18, 19, 20, I don't think these were objected to. 21. Yeah, 21. Let's get the, okay, so this is the email that Scout, Lindsay and Everett sent to their political consultant, Jeff Britt, and then Jeff Britt sent it to the governor's office, to Antonio Alfonso, who was the governor's chief of staff at that time. I think the objection here is that it's irrelevant and confusing. As to the confusing part and the prejudicial, again, going back to, and you can see this language, I encourage you to take a look at the Di Pasquale case, because it has a really good couple paragraphs that talk about how we don't worry so much about administrative hearing officers confusing the facts. You're experts in your field, you're experts at ethics, you know what the important things are in these emails that you can rely on and that tend to make a violation more or less likely, whether this is probative. It's juries we're really most concerned about being confused by. Furthermore, I
Don't you
assume
agree we are jurors?
you are jurors, but you're also, it's more like a bench trial, right? You're the finder of fact and the finder of law.
Mr. Chairman, can I just ask? I understand that's what, the case is cited. And I say this back to all commissioners. But Di Pasquale said, you know, not to confuse lay jurors, there should be a stricter applicability of the rules of evidence. For the most part today, we've had 4 lawyers and 4 lay witnesses. So does members, I'm sorry. Does that negate the applicability in any way of the De Pasquale case?
That's a great point, because that's the composition of this commission may be in question.
I'm just asking. Because you rated it as to lay jurors and as I said earlier, the lay jurors probably have more common sense than the attorneys.
I would say, if I could, is that the Administrative Procedures Act and administrative law really supposes that these people are not going to be former judges, and that it's often lay people who sit on administrative agencies. And that's the reason, that is the very reason why the strict rules of it, you're not expected to know or have to follow the strict rules of evidence. Instead, you're expected to be reasonably prudent people. And you should rely on the kind of evidence that reasonably prudent people would rely on in their duties. That's my how I see it. I can go back to Exhibit 31.
I would just point out as well that we will have counsel with us who could address some of the questions that the lay people, so-called non-lawyers, to their expression, may have. And I think that through the process of having the legal people on this commission, that we will be able to give the non-lawyer commissioners adequate basis to make informed, knowledgeable decisions.
For what it's worth, Commissioner, you can look up later that the pre-case that went to Superior Court, they applied De Pasquale to us.
We'll have counsel circulate the opinion.
Yeah.
Is that the pre-case that's what is cited in various Supreme Court cases?
The one that he appealed to the Supreme Court, but not on that issue. Two issues went up.
Okay.
We'll circulate it.
The De Pasquale case applies to administrative hearings. Now, in that case, it was a registry hearing, so it was a hearing officer. But it applies to, it doesn't differentiate or distinguish. This body's an administrative body, we're conducting an administrative proceeding, an administrative hearing, so De Pasquale applies, I view.
But there was no trial by the court company, by that individual.
No,
This is different now.
in De Pasquale, it was a license action before the registry. And basically the hearing officer suspended a Rhode Island resident's Rhode Island license based on his conviction in New Hampshire, based on a document that was transmitted by the New Hampshire authorities to Rhode Island.
Let me just raise this other point, and so it can be addressed. The fact that at various times in your proposed exhibits, reference was made to the person who accompanied Mr. Thorson to Philadelphia. And you have certain state employees who I believe are not doctors, making observations as to a medical condition. And when within state government, when you have a concern as to a medical condition of an employee, is that not confidential, or is that within the ordinary course of maintaining records?
I raised that issue at that hearing, if you recall. And I was shot down on that basis. And I still stand by what I intended to put forth, and that is by his own admission and everything else, without the medical records coming in, he shouldn't even been before us. The matter should have never been brought before us. He was not confident, even understand what was going on. But that's, and I get your point, George, and it's whatever.
Let's be clear for the record that what Commissioner Ritchie is speaking about is when the patent matter came
Yes.
before us.
Yes.
There was no prior discussion of any of the exhibits in this matter. As I said at the beginning of this hearing, we have had no knowledge until this motion was filed of what the exhibits are, nor did we have any discussion before we came here today.
They precluded patent.
So as far as, if I may,
Oh, please.
as far as the issue of, the mental status of this, public employee or any medical issues that are going on, in each case where I'm admitting a document, including 21 and 31 here, by the way, that may, this is a good example of why some of this is not even hearsay, why we shouldn't even be calling it hearsay in the first place. Let's stick to 21. This is the email that has all of the scathing email listing the offensive conduct that everyone is familiar with, by the way. This has been published. It's a public document. The Attorney General of the state of Rhode Island has ruled that it's a public document that has to be. I'm not admitting that.
Unredacted.
What's that?
The Attorney General has said it's a public document, unredacted.
It could have been. He said that you can, my memory of it is that he said to the governor, if there's some things in there that you think need to be redacted, go ahead and redact it. But I don't think anything got redacted, maybe an email address
In,
in 21.
so just for the record, again, reflecting that concern. In the end, we're gonna have an administrative record in this case. I believe it becomes a public document as an administrative record itself. And I know from my own experience in some matters that when it's subject to APRA and an administrative record, let me restate that. When an administrative record is presented, the Attorney General is concerned, the APRA people at the Attorney General is concerned about information like that becoming part of the public record of the administrative record. So in my context representing committees, I've taken the position that when the administrative record is prepared, that those kinds of matters can be redacted without our involvement at all, but in order to protect the, I'll say otherwise innocent. Now, that may not be what Mr. Graham or Mr. Bristow agreed to, but I can tell you that in my experience, counsel, everybody, nobody wants to harm. I'll use the word innocent people. We can discuss that on whether Mr. Patton's an innocent, but his medical condition does not necessarily have to be public after our proceedings. So that's all I'm gonna say is it could be redacted later.
But those, the statements that I'm expressing concern of were evaluations by lay people, not doctors, not psychologists, not a certified social worker. And I just raises the hair on my back that type of stuff is bandied about, and maybe I'm late to Mr. Ritchie's concerns that he expressed in the past, but it just raises the hair on my back, and that's not within the rules of evidence, but.
The traditional judicial basis for ruling.
Right.
So as to 21, one of the things that's important to note is that I'm not introducing this into evidence in order to prove the truth of any of the accusations that are in there. That's not the important part. That's not what I'm using to make my case. The reason why this Sunday afternoon email that was sent to the governor's chief of staff is important is because the timeline that it fits into. Lunch is Friday. Thorson doesn't pay. Friday night, Thorson doesn't pay. Saturday, Thorson doesn't pay. Sunday morning, Thorson doesn't pay. Suddenly, I'm going to present evidence, including Exhibit 27, which shows that Thorson becomes aware of this email, which he calls in Exhibit 27 scathing, email that Tony Afonso, the governor's chief of staff, is letting him know about. Suddenly, as we get into the next exhibit, suddenly the respondent is ready for an all hands on deck meeting first thing in the morning. The governor's chief of staff and and a personnel administrator to come up with a course of action. And it's after that, that Mr. Thorson sends an email, which is another exhibit, saying, thanks for lunch, but I need an invoice. So this email is not relevant because it says David Patton said offensive things. I mean, that's part of it, you know, it is scathing. It's the fact that it's scathing that makes it relevant, not why it's scathing. If I could.
And this is the last time I'm going off the reservation, if I deviated. But the prosecutor raises the point that he didn't pay on the day. But the investigation indicated, did it not? That there was no staff there to prepare a bill. How do you pay when you're not presented a bill?
I would suggest that this is an argument we're gonna have to make
Well,
then.
you raised it, I'm asking.
Well, if I give you my computer and don't give you a bill for it, have you accepted a gift?
I don't think that you have to answer that question. I think that's a rhetorical question, it may be, but it's not a direct question.
There's an appropriate time where obviously we'll have to answer that. And I appreciate the question and the thoughtful subject. So that's,
Mr. Chairman, apparently Mr. Kelly wants us.
When Mr. Graham's done.
We'll wait till Mr. Graham's done.
Okay, thank you.
And I will let Mr. Kelly speak, even though Mr. Bristow has the podium.
I was chomping at the bit to speak while Mr. Bristow was talking. I did that, but I'm gonna.
That's why.
I will defer to closing counsel.
Did you finish? No, I want you to, no, sorry, no, you misunderstood me. I want you to finish and then Mr. Kelly
Oh,
can speak.
Very well. Thank you.
Nobody's gonna interrupt you beyond what we've been doing.
So I don't think you're gonna find this confusing. I don't think you're gonna find this email, it's not unduly prejudicial. You know, I mean, all my exhibits are a little bit prejudicial to Mr. Thorson's case, right? I mean, they should be. That's why I'm offering them, because they're different than what his position. But the question is, are they so unduly prejudicial that they're going to confuse you? You commissioners don't have the capacity to be able to know what each exhibit is, what it's being offered for, what the probative value of it is, what weight to attach to it. I have confidence that you two have the ability to do so. That's exhibit 20. It's not 3, it's not check 24. 24 is a text, a set of text messages that Mr. Thorson's chief of staff sent to him. And the first one is the one where she's telling him that she thinks there might be a medical issue involved with Thorson's subordinate. Right? And the importance of this is I'm not trying to prove the truth of the matter asserted. It is irrelevant to me whether this person is actually having any type of issue. Why it's important is that it's timestamped, and it shows that on Thursday, March 9th at almost 10 p.m., 8 hours before the flight to Philadelphia, Thorson's chief of staff is saying something's wrong with the guy you're about to fly to Philadelphia.
How is that relevant to the violation of the ethics that
Appreciate
we're
that. And
focusing on?
my dealing with this case through the last couple of years, my reasonable assumption is that one of the defenses that Mr. Thorson is going to make an adjudication is that he assumed that David Patton was taking care of everything. And he put things into David Patton's hands to ensure everything was done appropriately. And it was reasonable for him to assume that everything was handled by David Patton. And so it becomes relevant when there is information that might show that David Patton maybe shouldn't have been relied upon for everything that you relied upon him for. And some of that has to do with his mental state 8 hours before the trip, his behavior during the trip, his behavior during the lunch. All of that becomes relevant when you have to decide, was it reasonable for Director Thorson to put so much faith and confidence in a person who there was beginning to become a fair amount of evidence you shouldn't rely on someone for those types of things.
But then there's the affirmation in the prosecutor's memos, we're not putting this in for the truth. I mean, now you're saying you're putting it in for the truth.
No, this is not going in. I don't need to prove that David Patton was having a problem. What this shows is that at this moment, Director Thorson's chief of staff was telling him there's a problem. Whether it's true or not.
Whether it's true that he was having a problem, not whether it's true that he helped him.
Right. It is true that the chief of staff said, my best guess is that this is what is, that this is happening. And, you know, and what you think about that is up to what you think about that. Maybe you think that's an important fact. Maybe you think, you know what? I don't think that's probative of these issues at all, and I'm not going to give it any weight. That's what you get to decide. This case is about me putting on the information that I have, setting it before the Ethics Commission, and whatever you decide, I'll go to bed at 10 o'clock like I always do that night and sleep soundly. So this is your job. My job is to put on the evidence. Your job is to decide whether it's any good.
Quick question, Mr. Chairman.
Yes.
How do you respond to Mr. Bristow's contention on this one, that this only shows that a text message was sent to Mr. Thorson, and we have no way of knowing if he saw it since there's no response from him?
Well, I would say, let's see what develops at the adjudication. Apparently, Mr. Thorson is going to take the stand.
What do you mean apparently?
Well, apparently, I mean, who knows?
Well,
I thought you were gonna call.
I am going to call.
all right, so it's not apparent.
It's, how do I know he's gonna be here? I've subpoenaed him. We've issued a subpoena. We assume he's going to be here, but we don't know if he's going to be.
Well, if he doesn't show up, we're not gonna be able to go forward, are we?
Yeah, I do. I'm ready to go forward.
What we heard before was that we heard it from the other side, but what we heard was that your only witness was gonna be Mr. Thorson.
Yeah, I am planning to call Jim Thorson as a witness in the prosecution's case in chief. Yes.
Okay. Just trying to understand.
Yes, absolutely. That is my intent.
Right.
So that,
When he could be asked about that text, that's
Right, he can be asked if he received any of these
correct.
emails that either was sent to him or he CC'd on, and the same thing with the text.
I'm simply saying whether or not I ask him about it, which I will. It should be this.
Mr. Bristol, I'm recording, you intend to call no witnesses, is that correct?
You know,
They haven't.
I'm sorry.
I don't think we need, I apologize to, I don't think we need to answer that question right now.
Right.
I think that we have our thoughts on that we are actively discussing between ourselves and with our client.
Yeah, my understanding is there's no obligation on the part of the.
No, I understand, I was asking whether or not, I thought in the beginning, you mentioned something about not calling, like, maybe I misunderstood it.
The only thing, what I mentioned respectfully is that I have been told by the prosecutor that the only witness that he intended to call in the presentation of his case to the commission was my client. He asked me if I would accept service. I accepted service this morning. Of course, I accept service. He's gonna be here anyway.
You address where you are at this point.
Yes, yeah, I believe.
Next one is 26.
Good. So I have to, I just want.
Actually, oh, yeah, because 25 is not objected to.
Right.
Again, eventual evidence. 26 is an email from Jim Thorson to Libby Kimsey. And then a thread beneath it of emails that have been forwarded to Jim Thorson. This is, so this is Sunday at 7:56 PM, Jim Thorson calling his chief of staff and saying, please call me ASAP. And then the emails, the reason for that, the text string beneath that is that Jim Thorson was forwarded an email at 6:38 from a DOA employee with an saying FYI, and underneath it, including a recounting of events that took place the night before the trip to Philadelphia at a dinner among DOA employees, at which Jim Thorson was present, and Dave Patton was present, and a few other DOA employees. And again, why is it relevant? Not to prove the matters asserted necessarily in the complaining employee's email, but to show that these other employees felt that David Patton's behavior the day before the trip was alarming. And there was something not right about it. And Jim Thorson was at that same dinner. One assumes he was there to see the same alarming
I'm
behavior.
gonna object. Is this an argument about an exhibit? Or is this an argument? Are we, one would assume that he saw the same things. I mean, where does this come
Mr.
from?
Bristow, this
it's-
is only argument and it's
An
only on
exhibit.
emotions.
Right, thank you.
It's only on emotion. None of this goes to the merits before this commission. We will only judge the case on what comes in at the time of the adjudication.
And I understand that, and I hope you understand my standing up here and saying, when someone is talking to you about my client's state of mind outside of this exhibit and what he is supposedly observing, it's argument, it's an argument, it's a presentation, it's a factual argument that's outside of the exhibit. Thank
An
you.
attempt to show relevance, though. Right? Isn't that what we're doing right now? Is relevance?
Until he starts talking about what my clients do. Okay, thank you. And if I was disruptive, I will.
No, don't worry.
I'll try, maybe I can get hot, so I'll try to keep it calm.
I'm not hot, I'm trying to be,
I'm not saying
trying
you are,
to
I'm
direct
saying
you away from myself.
You're doing your job, Mr. Bristow. We understand.
Yeah, I'm I've been asked to address why something's relevant. I'm doing my best to do so without being argument. But I will double up on it. Exhibit 27. So this is a kind of key document that goes back and ties in with Exhibit 31, which is the scathing email, which is what I'll refer to, 21 and 31. Here you can see it's an email from Jim Thorson to both his chief of staff and Pamela Montborelli, who's the DOA HR person. The time is 8:02 PM Sunday night. And what he says to both of them is, first of all, that he spoke independently with the people who told him about what happened the night before. Right? But also, more importantly, in the middle of this email, also Tony Afonso called after a scathing write-up by Scout, detailed unprofessional and inappropriate behavior while we were in Philadelphia. We need to be prepared to take action tomorrow. I need to know what options we have. Dave's scheduled for a one-on-one at 9:30, and I need Pam there. Tony will also attend. Libby, I think you should not be in that meeting. So why is this important? Because up until this time, there had been, we have the lunch had not been paid for. And now, on finally Sunday, we see that problems are arising. The governor's office has been advised that there was a problem on Friday. Now, an action plan has to be put together for Monday morning. What else happened Monday morning? Thorson's email to Scout saying, thanks for the lunch. I need an input. So it is highly relevant as to whether or not on Friday, Mr. Thorson accepted a gift of a lunch that he didn't pay for. And when he decided he needed to pay for it, and under what circumstances he decided he needed it. Exhibit 28 is a text message between Thorson and Chris Farrell, who's a special advisor to the governor, a week before the Philadelphia trip, advising Farrell that he and Pat were planning to go to Philadelphia to do due diligence. Why is that relevant? It shows the purpose of the trip. Thorson is involved in the state's due diligence of this vendor who gave him lunch. Those are important elements of this case. Part of the due diligence team for Scout. Exhibit 29, more text messages between Thorson and Farrell, this time immediately after the Philadelphia trip. You can see, barely, but you can see that it's Saturday, March 11th. And this is where Chris Farrell says, I'm with the governor right now. How was the trip? So it's the day after the trip. And it's relevant here that at this point, when there's no scathing email out in existence, the answer is checked all the boxes. Full report Monday, checked all the boxes though. Then a report on how the trip went. Later on, we need to do this, but figure out the best way to finance it, is what Thorson is telling Farrell. So there's still, discussion about that Thorson's involved in the decision to do it. Thorson's involved in figuring out how to finance it. And it's also relevant that at this time, the day after the trip, Thorson is not saying, uh-oh, we got a problem. That happened Sunday after Tony Afonso advises him of the scathing. Exhibit 30 is David Patton's memo that he wrote on stated, I believe, Sunday, which is March 12th. It's his memo of what happened during the trip. That's relevant because it shows what happened during the trip. It talks about the lunch at Bach, gives a little information on the lunch at Bach. But also even more important is in the middle of page 2, it notes that there are still options out there to finance the project or kill the project or go full speed ahead. And then at the end of it, there's an approval line on this memo for Jim Thorson to sign off on this action plan. So again, it goes to show that Jim Thorson was fully involved in the state's, even at this date, fully involved in the state's decision whether or not to kill Scout's project, to go slow on Scout's project, or to go full speed ahead. And those are all that are.
Yes, I think we should take just a few minute break at this point.
Yeah.
We're on the record still, shall I?
Oh, yes, please.
Are we taking a-
We're gonna take a sufficient break and we should go off the record. Thank you. For that. Yeah.